Good afternoon, good morning, depending on where you all are from. I'm Stuart Discount. I'm the chairman of the Enterprise Communications Advocacy Coalition. Welcome to our monthly educational webinar. This month, Navigating the Risks of the Reassigned Numbers Database. We have these webinars monthly. Cal, you want to go to the next slide then? I wanted a little tell you about the Enterprise Communication Advocacy Coalition, or ECAC. We're about a 3-year-old, soon-to-be 501c6 trade association representing the contact center industry. Most of us that were originally from PACE and their legal and outreach advocacy part of that association, and PACE no longer exists. I want to tell you a little bit about our member partner events, benefits. So we have webinars each month on topics. This month is the R&D. Last month was on, well, next month will be on privacy. And then in June, we're having one on how regulations affect the valuation of your companies, specifically the contact center regulations, both federal and state, and how they affect it, especially in mergers and acquisitions. So we'll have these every month. We also have some new things. One of the things that PACE was always good at was, our compliance, our adherence to compliance. We were respected by the FCC, the FTC, because we made sure our members knew what they were doing. So we have 2 safe harbor tools that we're developing right now. One is a safe harbor self-assessment tool, where a company will be able to go in, answer questions, go through this self-assessment and find out if there are any holes in their compliance processes. And then if there are, they can go to one of our many compliance members who either, some of the companies that are compliance companies, or through lawyers, and figure out how do they fix what's out there. We also have something that we rolled out hopefully soon, is an AI safe harbor guide. So you'll be able to go to the safe harbor guide. You'll be able to ask a question, say, when did the TCPA come into effect? And it answers it immediately. The goal is to have the TCPA, the TSR, all state regulations, all privacy regulations within this tool. And so this will be a way for your compliance folks at your organization to actually get some questions answered. Not legal advice, but we'll be able to get really easy questions. If you want to know what the calling hours are in Oklahoma, you'll be able to find that in a second without going to Google, without going to looking up a guide. This will be able to answer those questions. So that's coming out. We already have the TSR and the TCPA in there, and we're testing it now. Last thing we have is a membership directory, and this is coming soon. Our companies, our member partners, will be able to add themselves to this membership directory. There'll be a link to their website. They can advertise their products. The goal is that we want our member partners to do business with other member partners. We're trying to build a community of people doing business with each other that are like-minded, have the same, same hopes and dreams for our industry. And so we hope that should be in a couple of weeks. The last thing I want to talk about is our councils. We have 4 councils where we're going to focus all of the activities. So the Safe Harbor Education Council, our webinars is part of that council. Beyond that, we're going to have some other programs that we'll develop, but that's one of the councils. Our PAC Council, which will be our Political Action Committee, that we eventually will get started. And the last 2, Federal Regulatory and Legislative Council, and then State Regulatory and Legislative Council. This is part of our advocacy. This is where, if a bill comes up in Congress, we will come up with a strategy, at least how our member partners are going to reach out and tell our side of the story. And that's something that is already what we've been doing for the last 3 years. I mean, we've met with the FTC and the FCC several times, and we've had 30, 40 meetings with congressional members and their offices. So we'll continue to be out there in front when it comes to issues. We've answered a lot of requests for the NPRMs, and we'll continue to do that. So we'll be reaching out to you if you're not a member partner. Some of you are not on here, member partners, and we hope you eventually will, and we'll be reaching out to you. So without further ado, we're going to go with this is a very important topic today, very important, and we have the best people that are going to answer the questions of what your risks are and why it matters and all of that. So without further ado, I'm going to introduce first our moderator today, Mitch Roth. Mitch is a founding member and CEO of the law firm Roth Jackson, based in McLean, Virginia. Mitch was instrumental in the founding of ECAC and serves as its general counsel. He has counseled clients on TCPA and TSR compliance for 25 years and defends clients in class actions, regulatory enforcement actions brought by the DOJ, FTC, FCC, and state attorney generals. We also have Beth Sprague, and currently serves as Reassigned Number Database Administrator for Somos Gov Incorporated. In her current role, she is responsible for ensuring telecom providers report their disconnected telephone numbers in accordance with the FCC mandate, as well as managing the continued operation and evolution of the database with the goal of protecting consumers from receiving unwanted texts and calls. Stephen Dunnigan currently serves as the Vice President of Field Operations at Griffin AI, with nearly 30 years of experience in communications and other networks, seamless interoperability between complex technology platforms, and sales engineering. Stephen is responsible for the operational strategy and performance of Griffin's field operations and the management and execution of key initiatives that drive revenue objectives and growth opportunities. And last but not least, Mark Silver is a partner at Denton US LLP law firm. Mark practices involve all aspects of commercial litigation, with an emphasis on class actions brought under the TCPA and related state and federal statutes. Based in Atlanta, Mark has assisted startup companies to Fortune 100 companies with class action litigation and compliance. Mark also advises businesses on other consumer protection matters, including before federal and state regulatory agencies. So Mitch, I'm going to turn it over to you now to get things going.
Thanks, Stuart. Good morning or good afternoon to everyone. And Stuart, before we start the substance, let me wear my general counsel hat and read this disclaimer. The materials and the discussion on this webinar is not intended to constitute legal advice, and all attendees are reminded to address any specific issues or any specific questions that they may have regarding these materials with their own legal counsel. So before turning this over to our subject matter experts, I thought it would be a good idea to just kind of set the stage and put some of these issues into context. The FCC first announced the creation of the Reassigned Numbers database in December of 2018. It ultimately went live and in effect in its final version in November of 2021. And the problem that it was trying to address were those situations where businesses thinks that they are calling one person, presumably based on some form of consent, but they're actually calling someone else because that number has subsequently been reassigned by and obtained by a new consumer, a new subscriber. This became a real problem for businesses because courts have been interpreting the relevant parts of the TCPA as being a strict liability statute or regulation, meaning that the risk is on the calling business if the number had subsequently been assigned, and that had placed those calling businesses in significant risk and peril in especially class action litigation. So let me stop there and pass this to Beth Sprague, who can discuss some of the mechanics of the R&D. Beth, you want to take it away?
Sure. Thank you, Mitch. Yes, my name is Beth Sprague. I work for Somos Gov, and Somos Gov, just so everyone understands the relationship, Somos Gov currently administers the Reassigned Numbers database pursuant to an FCC contract, and that contract was awarded to Somos in December of 2020, and we launched the R&D service on November 1st of 2021. And you can move on to that next slide that talks about pretty much why it was created. As Mitch noted, this came from a 2018 order on advanced methods to target and eliminate unwanted robocalls, and it's also known as the Reassigned Numbers Database Order. Some of the reasons behind the creation were that number one consumer complaint, the hundreds of calls that consumers were calling the FCC complaining about robocalls. That was one of the hugest reasons. And also then on the other side, those legitimate businesses that were constantly being exposed to TCPA violations. At that time, companies, these are legitimate businesses that were trying to do the right thing. They would have to go to different multiple sources, and some of these sources might not have been complete or might have just been very expensive. So the solution was the creation of just one centralized database of disconnected telephone numbers. And you can move to the next slide. So the other important piece of the order was the creation of a minimum aging. So the order created the minimum aging period of 45 days. Before the order, there was no minimum aging. So if a number was disconnected, the carrier could reassign that number the next day. So the minimum aging plus the R&D database that gets updated once a month works really well. If a number gets disconnected in a given month, it's not going to be reassigned until after the next refresh. So that new consumer is ideally going to be protected from unwanted calls and unwanted texts that were meant for the prior customer. And that is assuming that companies are actually querying the database before making the outreach. So you can move on to the next. This is just some history. So starting out, well, the order did mandate that all carriers report, not just wireless. This is wireless, wireline, VoIP resellers, all of them report disconnected numbers. And this is every month, the 15th, no later than the 15th. Just a little bit on that. Carriers don't have to wait until midnight on the 15th. They can report as early as the 11th. So there is some cushion there for those carriers. And the toll-free number administrator reports on the toll-free numbers. So going back to the history, originally, the majority of carriers, large and medium-sized carriers, they were ordered to start tracking their disconnects July 27 of 2020. And the first time that they reported all those disconnects at 6 months worth was April 15, 2021. There was small providers had an extra 6 months, so they didn't have to start tracking until January 27 of 2021. That's a really important date because that's the date that the database was considered complete. And you can keep moving on because I think this is animated. So, yeah. So there's the first date. April 15 was the very first reporting date. And then you can keep going on. It will give you a few more bullets. Yeah. And every month thereafter. So you see over on the side, there's a definition from the FCC order about the permanent disconnect. And there was a clarification in there about what the permanent disconnect means. Specifically, some of the clarifications are this does not include ported out numbers. And so that started April 21st and every month thereafter. And we did get a lot of questions in the beginning, especially from the carriers. They were saying, well, we're reporting the disconnects, but how are you going to know if it's reassigned? And that is not a requirement. The only requirement is to report the disconnects. The R&D, it's not a database of currently disconnected numbers. It's just a record of when a telephone number has been disconnected. So all the numbers stay in the database even after they've been reassigned. That's what you'll see later on in this deck. We'll mention that there are over 530 million telephone numbers in the database. That doesn't mean there's 530 million disconnects right now. It means there have been 530 unique telephone numbers reported as disconnected since we started tracking. So I think you can move on. Oh, one other thing. That's okay. You can leave it. The R&D, it's the only source that you can get safe harbor if you are a querier of this database. So if you move through, this is just a depiction showing the both sides, the carriers that are reporting, and then on the other side, the major incentive, I think, for someone to use it is to gain that, if you need it, the safe harbor from TCPA fines. So moving on, you can move on to the next one. And this is just how simple it is to query the R&D. It's just made up of, the query is made up of a telephone number and a consent date. And for the purposes of the R&D, the FCC defined this date can be the date the caller received from the consumer or a past date on which you were reasonably certain that that number could still be reached, that consumer could still be reached to that number. And an example given in the order is the date that the consumer last updated their contact information. So basically, the query results are either going to be a yes or no. And I say that basically, as long as the consent date is January 27, 2021 or later, you're only going to get one of two answers. Yes means that telephone number has been reported as disconnected since the date in the query, so probably not good to contact that number, or no, meaning the number has not been disconnected or has never been reported as disconnected. And the no is what you would need to retain in case you ever needed to prove, got a demand letter or whatever, you need to prove that you queried the database. We've got lots of different ways to query the database. So it's, like I said, it's very simple. You can query directly through the user interface. I think up to 50 telephone numbers. You can upload a file of up to 1 million numbers. You can use SFTP, which is a secure file transfer protocol, up to 1 million numbers. You can upload a file through the API. You can also use the API for API calls. That's 1,000 numbers per API call. So lots of different ways how to query. So moving on to just the definition from the statute, and you see I put the CFR reference down there for all the lawyers. Just in case you need to prove safe harbor, avail yourself of the safe harbor. Those things you have to prove are that you obtain the consent and that you check the most recent database, the most recent refresh of the R&D database, and that the response was a no. We get a lot of questions about from some of our subscribers saying, how often should we query the database? I know that there's a lot of different types of industry segments that have opinions and best practices, and we simply reiterate what's in the order, which is you have to have shown that you queried the most recent refresh of the database. And that is refreshed every 16th of the month at approximately 4 p.m. Eastern. Notifications go out to all the users. We also have an API call for those that don't want to have to wait for an email. So that's everything on that slide. I think you can move on. This is just kind of showing who's using it. Basically, any entity or enterprise that calls or texts for things like appointment reminders, service renewals, customer service notifications, or any like value-added service offers should use the R&D. And we have a huge makeup. We have like huge corporations down to very local pet groomers, that kind of thing. This is a prepaid subscription service. So there is a payment required. And I will note that on April 7, we put out a notification and the FCC issued a press release. We're doing a reduction across the board of 20% for all tiers. And we're also introducing 2 more tiers. So this really covers all levels. And that will go into effect on Monday, April 28. And that was a result of feedback from our users. So I think you can move on to the next slide. This just kind of shows the wide adoption and the use of R&D, and also the adoption by regulatory entities. Many of them have adopted it as a necessary tool. You'll see the CFPB right around the same time that we went live. The Consumer Financial Protection Bureau, they included the use of the R&D as part of their amendment known as Reg F, Regulation F, and it was related to modern channels of communication, specifically how debt collectors make text contacts. And in the Regulation F, the R&D is noted as complete and accurate database to confirm that a telephone number has not been reassigned. And it can also be used as a separate type of safe harbor related to unintentional disclosure of third-party information. So we do have a lot of debt collectors that use the system. Also, another one is Department of Health and Human Services. Back in 2023, Health and Human Services was looking for some help from the FCC on how they and their contractors could make sure that enrollees in different programs make sure they are contacting the right person. And this declaratory ruling shows that the R&D should be used. They just encourage everyone to use robocallers and robotexters to use the R&D and take advantage of that safe harbor, especially since so many of them, and we see this on the state level too, a lot of state health departments use it and their contractors. So we see a lot of that. And then also the Office of Controller of the Currency, they included the use of the R&D in their bank examination procedures. We also see a lot of trade associations, self-regulating organizations. We mentioned REACH, Responsible Enterprises Against Consumer Harassment. They included the use of R&D in their standards, which were created in October of 2023. And then over on the right, you see the state of Maine. The actual their own state-specific law requires the use of the R&D, and that requirement went into place in August of 2024. And you can move on to the next one. This just talks about more benefits. I spend a lot of time talking about safe harbor and how that's a great incentive, but there's also a lot of other benefits that our users have told us about, and one of them is saving time and money. You're going to help reduce operational expenses when you're checking one database and scrubbing an outreach list. Another one is protecting your brand. Less calls to the wrong consumer is definitely going to help a consumer's trust in a company's brand. No brand wants to be seen as a nuisance caller or even possibly labeled as spam or spam likely. So there are more benefits other than just the safe harbor. I think that you can move on to the next one. And this is just some stats that we've had since the beginning. Like I said, we have 530 million, over 530 million numbers. This number continues to grow. When we started out with the seed data, it was about 100 million, but we continue to see more and more. In the beginning, it was something like 20 million every month. Now we're seeing that closer to 26 million reported every month. So it does continue to grow. Since the beginning, we've seen about 6.3 billion queries of the R&D, and we think that about nearly over 500 million calls or texts to the wrong person have been avoided thanks to the use of the R&D. And I think that's about all I was going to provide, and we have some contact information just on the last slide, and then I'll send it back to Mitch.
Hey, Mitch, real quick, if anyone has any questions, they could type them in the chat box, and we'll get to those questions. Got to mention that.
Beth, what kind of numbers are on the R&D? Cell phones, residential, toll-free, all of the above?
All of the above. Yeah, all of the above, since wireless, wireline, all carriers, any carriers that get numbers, and then toll-free number administrator reports the toll-free numbers separately. So they're all numbers.
You know, and I'm really dating myself, but Stuart will remember when we were active with ATA, there were congressional hearings back in probably 2005, 2006. And one of the congressmen at the hearing that I think Stuart and I attended asked the chairman of the FTC, well, how are you going to get numbers off of the do not call list? And he says, well, that's real easy. We're going to consult with the National Disconnect and Reassigned database. And this was in 2006 or 7, probably. And it sounded like a great answer at the time. And it wasn't until he was fact-checked later that it came out that there is no National Disconnect and Reassigned database. So it took probably about 20 years for that to happen. Stefan, I'm going to bring you in. You're a user of the R&D. What what have you seen, and what's been Griffin's experience?
Yeah, that's great. Great question, Mitch. If we could just, I'm going to talk a little bit about R&D and the overall user experience. Next slide. Just sort of baseline, Griffin AI is a Boston-based software as a service company, and we have around 25 years of experience in helping companies comply with the various contact compliance rules across channels. And that's really before, during, and after the interaction. R&D is new to that process and newer to that process. From a user perspective, we are a approved R&D caller agent, which means we represent a client base that needs access to the R&D system. So in essence, we represent them by agreeing to terms and conditions of use and proper use of the R&D database, and we query the R&D database on their behalf through what we call our intelligent contact compliance platform. Beth mentioned a number of the objectives, but the main objective for our customers is adherence to regulatory compliance needs, right? For calls and for texts, which is what Beth had mentioned. Things like TCPA and making sure you have you're capturing consent, and especially if you're using any sort of automated platform or pre-recorded messaging platform for outreach. Beth mentioned Maine. Maine is a newer requirement that came up last year, meaning it doesn't only have to be an automated call. If you're manually calling into Maine for any purpose, you need to make sure you're querying the R&D database. And you think, all right, well, Maine is smaller in terms of population, not a big deal. However, a lot of these states are a little bit on the copycats in terms of legislation and how they move forward. Think if Maine is California or New York or Florida or Texas or a combination thereof, right? What would the impact be to your business? So, I don't know what the future beholds, but I'd say some of these other states will probably be looking at what Maine's doing and potentially introduce their own requirements around R&D. Beth mentioned achieving safe harbor, right? Making sure that at least if you can achieve it, if you send in a last known contact date, consent date with a record, and the system responds back that no, the number has changed ownership, you potentially can achieve safe harbor that way. And then lastly is we've seen more and more scrutiny around reassigned numbers, right? More and more fines and penalties. We're seeing it on a regulatory front. We're seeing it on a class action front. It just seems to be the new frontier from a enforcement perspective and a litigation perspective. So you should certainly pay attention to R&D and the data set itself. And if you could just move forward. So when you think about who uses the system and for what, right? In our experience, any sort of outreach, and that spans sales, that spans marketing. Marketing is when you're building your list and before you disseminate them out, checks at that level. Servicing, so things like appointment reminders, prescription reminders, any type of outreach, especially with pre-recorded messaging and automated outreach, that's a consideration. And as Beth mentioned, consumer debt collections, and this is a little bit building on what Beth had stated from what does the client base look like and the clientele look like? Well, it spans financial services, healthcare, vacation ownership, insurance, and many others. And from our perspective, we support customers using the R&D database that are both higher in volume and lower in volume, and that can span hundreds, if not thousands, of calls a day on the lower end, up to tens of millions of transactions a day. So there's a big range there. And then collectively, us alone, we're in the hundreds of millions of queries against the R&D database, and I know cumulatively across all the industries and all the organizations that are leveraging the database, it's in the billions. So it's a large volume database, but I think you have to look at the grander picture. It's in the billions, but there's a lot more outreach is happening there. If you can move forward. So our main use cases, we talked about cleansing your client database, your calling list, your lead list, ensuring that there's no one on that list that has changed ownership, and then treating them accordingly if they have. making sure you run hygiene against your proprietary consent database and in some cases your EBR and exemption databases. Just again, verifying whether a number has changed ownership, especially if you're going to dial it through some sort of automated means. And then lastly, a number of our customers are using it now to identify numbers on their opt-out list that potentially have disconnected and have changed ownership. And how do they want to treat those numbers from a contactability perspective? So there are a number of use cases. I'm not touching on them all, but it could serve multiple purposes. If you can move forward. So Beth touched on some of these on a high level, but I wanted to really drill a little deeper into how you access the system and the overall performance. And there's really three main ways to query the R&D database. There's the API version or web service version that was mentioned. There's a secure file transfer process. And then there's also a web interface or a web GUI that was mentioned. Just getting into the API version, it's as simple to utilize a RESTful API. There's caps in the number of requests per second, which is 50, and then you can have up to 1,000 records or in that each of those requests. It's more efficient to send fewer requests and larger payloads with larger payloads than it is more requests with smaller payloads. So if you send, say, 500 records, 500 requests with 1,000 numbers, you're going to get much more efficiency back than you would the alternative. And what we found and what our customers have found is it's a much better tool, meaning the APIs for smaller requests. And from a performance perspective, over the course of 12 months, 95% of those requests have come back in under 4 seconds. So it's not terrible from a response perspective. Just drilling down a little bit on secure file transfer. Users can transfer files with a max size of a million numbers per file, and expect the results to come back in a few hours, if not sooner. And from a performance perspective, figure 95% of those requests over the course of 12 months have come back in 2 hours. So whereas APIs is probably better for smaller requests, larger requests and larger processing of data is much better served through the file transfer process. It's just the way that it works. And if you could just advance one more slide. You have the web interface as mentioned, right? So these are built for one-off, go to a portal, drop 50 individual numbers in there, submit them, or load a bulk files in as a CSV or an Excel file into the system, and you can expect to get those requests back in around 2 seconds, right, or under 2 seconds. And again, 95% of those requests over a 12-month period have come back in under 2 seconds. And the last thing I do want to touch on is there are other things that are supported through the reassigned number database, right? So if you do visit the site, you have access to query reporting, right? So you can see what your activity looks like. There are biannual, annual, quarterly statistics. So things like how many numbers in the database, which Beth touched on, how many certifications have transpired or queries have transpired, how many have come back as yes, they've changed ownership versus no, they have not. All that data is readily available in the interface. And then information on how to better utilize the R&D database, right? User guides, training videos, other types of resources, subscriptions. Like us as a caller agent, we're submitting a letter of authorization for each one of our customers that we're acting on behalf of. We can manage all those subscriptions there. We can manage our thresholds. We can look at utilization details. There's a lot of information that's readily available to there. Hierarchy administration. So we have allocated users within our organization that have access to the system, and we can basically determine what we want them to be able to do once they do access the database. Automatic data processing and update notifications. Beth mentioned the data is updated once a month. There are notifications that go out stating that, hey, the data is now available. When you process a large file, you get information back saying, hey, the file's received and has been processed. And then there's a full support desk behind all this, meaning it's supported by the organization. If any issues surface, email, phone call, and you have someone at your discretion to work through any issues you may have. And that's it.
Thanks, Stefan. Stefan, I have a question. Over the 4 years or so that this has been up and running, have you seen any trends over the use of the R&D?
Well, I definitely see utilization trending up. Now, is it exactly where it needs to be? Probably not. I mean, I think there's a lot of learning that needs to happen in the marketplace, right? In terms of the need to use it from a regulatory perspective and otherwise. But we did definitely see a trend going up, at least among our customer base. And I think just generally the statistics we see across the platform, there is a increase in volume. Now, I will also say this, Mitch, and it's a vital data source, right? We're seeing more and more scrutiny around utilization of the system, as mentioned. There's more and more around R&D from a regulatory and a class action perspective, and I believe you and Mark will probably talk in more detail on that. But if you're doing outreach, especially through any sort of automated platform, or if you're reaching into Maine and you're not using R&D, you're probably not doing yourselves much justice.
Well, that's actually a good segue to get Mark's thoughts on this. Mark, my guess is that you've probably seen 1 or 2 lawsuits where one of your clients is getting sued by someone who was looking for somebody else.
That is correct. And what I will tell you, and it kind of goes to Stefan's point just now, unfortunately, a lot of my clients, even fairly sophisticated ones, are not, I will say, on purpose, not running against the reassigned number database. It more happens to be that this is a relatively new resource that I think recently has been doing a really good job of getting out there, but I think it's just for some reason not gotten to all segments. And so when they get hit with one of these lawsuits, they come back and say, hey, I've got this consent information. And we kind of look at it, and sometimes the name is not adding up to, the person bringing the lawsuit or the person sending the demand letter. And, recently we've been seeing a lot of those demands and lawsuits being filed, I would say, since October or November of last year. And unfortunately, again, it's not a situation where most of my clients who are getting hit with these are saying, I knew about it, I just didn't want to run it because I can't afford it or anything like that. They're saying, this is the first time I've heard of it.
Yeah, I've had a similar experience when I'm counseling my clients on compliance. And going through the requirements for a compliant campaign. And then unfortunately on the back end, when they get a complaint and I ask them if they're using the reassigned number database, unfortunately, a lot of times I'm getting blank stares. So I don't know what to do about it other than, these kinds of seminars to spread the word. I guess maybe leave it up to Somos and companies like Griffin to educate your clients on it.
Yeah.
So, I mean, Mark, these lawsuits, they're kind of a cottage industry in and of themselves, like what I'm finding, at least. You have civil litigators, and then you have class action litigators on the TCPA issues. But now you have TCPA litigators on one hand, and then TCPA litigators that are specifically focusing on the R&D issues. At least that's what I'm finding. What do you see?
Yeah, no, that's what I'm finding as well. And unfortunately, I think that indicates that this trend is about to get even bigger than it is, because we've really seen these lawsuits recently filed by a select group of the main plaintiffs' attorneys in this area. But that generally is what happens in this field. Someone will find a new area and they'll start filing stuff. And then we see it kind of expand out to more universally accepted. What we hope at the same time is happening, and again, while we're having these seminars, is that more people are adopting the reassigned number database. So they're not going to get hit with as many. But that is kind of the trend that we are seeing. But Mitch, like you said, we are seeing a cottage industry here. Obviously, the TCPA, a lot of people would call that itself a cottage industry. But in this reassigned number database, we are really seeing complaints that are just tailored to the reassigned number database. You mentioned this earlier, Mitch. are you seeing, I guess you're not seeing a lot of people reach out to you for compliance on the reassigned number database. I would assume that they're reaching out to you for TCPA compliance and you're having to bring it up to them.
Yeah, that's exactly right. And again, because people don't know about it.
Yeah.
I made a comment a couple of weeks ago that if you think about like when the DNC registry went into effect, which was, it's similar subject matter, different. I certainly understand that it's geared towards different audiences, but there was so much outreach about and information about the DNC registry for consumers. Trying to encourage them to get their names on the registry, but there hasn't really been any effective outreach to the call center industry, in my experience, to educate them about that. And part of it is probably because of just the different scales of entities that are out there. You have the large publicly traded call center entities, who certainly know about it. But then still the telemarketing industry is still made up of mom and pop businesses that are trying to sell, health insurance or bring your car in for an auto change, right? As simple as that. And they certainly don't know about it. And in that latter example, you're trying to sell a $75 oil change, and you're looking at a $1,500 liability if you make a mistake. So the numbers are kind of backwards on it. In fact, when I do mention it to companies of that size, they just prefer to self-insure, which really means just close, pray before you go to bed at night.
And Mitch, to that point, when you look at the statistics, right, you look at the number of records that have been disconnected and potentially changed ownership, it's been gradually growing. I mean, it's bordering on 7% as of the first quarter. It's nothing to sneeze at. When if you're doing any volume of outreach, whether it be through the telephone or text, 7% is your potential liability. Quarter over quarter. I mean, it was roughly 6 fourth quarter of last year. So, and that's a sample size of billion plus transactions. So, I mean, there is a ton of liability potentially that's out there, especially when you factor in how litigious we see things happening from a class action and a civil perspective.
There was data.
And historically, just really quickly on that, Mitch, historically in the TCPA world, we were seeing a lot of what I will call people calling stale leads that would lead to the most liability. I would still say that is the most liability. Obviously, there's a larger chance that you calling a phone number 6 months after consent is going to be reassigned than calling numbers after 1 week. But as Stefan mentioned, we are seeing now individuals who are getting these reassigned number text message or calls and then suing a few weeks later. And so it's, not just the stale leads that are calling, and these are people who got reassigned a few weeks ago.
One thing I was going to say, and then I'll ask my question. I had data, I'm going back probably 10 years or so, which indicated that 1 out of every 5 telephone numbers change hands every year. In other words, people on average change their telephone numbers every 5 years. Now that's well before the proliferation of cell phones. I get that, where people are ditching the landlines and just holding on to their cell phones and keeping them from one area code to another, depending upon where they live. But there clearly is a rapid turnover, I think, Stefan, to your point, of telephone numbers that needs to get addressed. And with that, I forgot the question I was going to ask. Oh, Mark, I do remember. Does this subject or this type of lawsuit lend itself to class action, to the formation of a class? Are they easy to defend on a class-wide basis at the class certification stage?
So I will reiterate again that these have recently spawned up. There were 1 or 2 cases that had been litigated over the years that kind of morphed into more of a reassigned number database case, but we're really seeing these cases pop up again in the past 6 to 8 months. What I will tell you is every single one of them has been a class action, and all of them are, or the vast majority of them, if you check the public dockets, are being actively litigated as we speak. So the plaintiffs' attorneys think that this is an amazing opportunity to pursue class action. They say, hey, someone got a reassigned number database. They're not the intended recipient. Let's put them together as a class. Let's run it against the reassigned number database. There we go. We have a class. They haven't been tested yet. We haven't been tested yet, but I obviously push back on that. As we talked about before, I think the name reassigned number database is a little bit misleading because all of our clients, and I see Beth shaking her head as well, all of our clients assume based on that they are getting an indication that this number has been reassigned. But as Beth very accurately outlined at the beginning, all it is showing is a permanent disconnect. It is not showing what happened 45, 47, 90 days later. If it was given to someone else, if that other person, kept it for a while, if that other person then reassigned it. And I think critically as well, I don't want to get too much into the weeds right now, but remember the TCPA has lots of distinctions between cellular telephones, residential telephone numbers, business phone numbers. All of those phone numbers can go on the reassigned number database. But for example, a business telephone number cannot be sued for under the do not call list provisions. So we are heavily litigating these cases. I hope we are successful, but the plaintiffs' attorneys, I would say, are equally convinced that they are going to have a gold mine here.
Well, you just mentioned something which, I think, Mark, you and I may have talked about previously. And that the safe harbor comes up in the TCPA regulations in the context of calls that require prior express written consent. And it's really in the subdivision of calls to cell phones and calls using pre-recorded messages. But there is no specific safe harbor for DNC violations. Do you agree?
I would agree.
So I think that's important for people to keep in mind that this is really from a litigation standpoint. Now look, is it good to get, is it still valuable to run your numbers up against the reassigned number database? Absolutely. But from a regulatory safe harbor provision, you're only getting protection for the calls to cell phones and the pre-recorded messages.
Correct. I will say that the case law has been pretty all over the place on that. I will also say that what has been really interesting recently is that, and this is just a trend with the US Supreme Court itself, there has been a lot less deference given towards the FCC and other governmental entities. And so there has been a lot of case law, for example, and Mitch, I know you and I have talked about this, that cell phones can be considered residential or that text messages are considered calls. Those have been quote unquote established by the FCC for, in some cases 20 years. But in the past year or two, the FCC or the Supreme Court has started saying, whoa, we're not going to have to give as much deference. So one of the things we are also litigating, and it's related to what you're saying, Mitch, is all of this, what I would call bad case law that's before, that's not what was ever intended by the statute when it was passed 30 something years ago. We need to go back and address this anew. Does the word call really mean text message when text message didn't even exist when we had the enactment of the TCPA? The plaintiffs' attorneys push back on that and say, well, this is going to lead to a parade of horribles. Obviously, the FCC says that it was meant to include that, et cetera. But what I push back, and Mitch, I'm sure you say this as well, is the statute says what the statute says, and the regulations say what they say. So again, I think there's a lot of new arguments that are coming up. For example, as you said, the safe harbor applying to the DNC, et cetera, where we're challenging what has been, what I would say, almost established case law for about 20 years. In light of that, Mitch, I do have a question for you. How are all these, what I'll call creative arguments we're making, how are they factoring into the advice that you're giving before the litigation comes?
You mean at the outset in terms of creating the compliance program?
Yeah,
Or-
when someone calls you and says, hey, I want to create a compliance program. I've read all these things that text messages shouldn't be included as calls. I think that's going to change. Can we adopt, et cetera?
So, I always tell them that, I only have before me what I think you and I would consider to be the questionable case law. And I get to build my compliance program based upon that case law, knowing what the current, what the current state of the law is. I leave the creation of the new case law to litigators like you, Mark, and others. I absolutely agree with you. I don't see why a cell phone, a text message, is a telephone call, right? I just, the technologies are different. It shouldn't be. But I tell my clients that this is the current state of the law. If you want to create a compliant program and you want to be as conservative as you can so that you don't need Mark's services down the road, because your services down the road are much, much more expensive than my services before those lawsuits are filed, then this is what you do. And I push them to the R&D, and I push them to the DNC registry, and I get the luxury of being in in an ivory tower and telling them this is everything that you should do, and this is the current state of the law, and then it's really up to them how much time and unfortunate money they want to spend on it, and every company has to make their own decision on that.
Yeah, Mitch, and along those lines, from a client perspective, like the trust, as we all know, in the phone channel has been dwindling. It has over years, and you're seeing more and more outreach through SMS and text because of the the ability to get contacts through, right? I mean, it's 90% plus. You're going to at least have someone respond on the other end. So, it's a conundrum that every organization has to sort of weigh. Being able to reach more people and have them, see whatever your message you're trying to get through or brand you're trying to promote, or not, right? And it's just, that just puts more and more scrutiny around text and that ambiguity around the law, right? That exists from, nearly 4 decades ago exist.
Yeah, for sure. Beth, what have you noticed? I mean, Somos has been at this for what, 3-4 years now. What have you guys noticed in terms of trends or challenges in the operation of the R&D and the data that you guys are getting?
Well, I can tell you it was a lot more than we had envisioned, a lot more volume, and then also just on a monthly basis, the amount of disconnects that are reported. It's actually increased. Earlier, it was something like 20 million a month, and now it's an average of 26 million. So I'm just surprised how many numbers are reported as disconnected. I know there's a lot of different theories on why, but I don't have insight into those theories. But I've also been surprised, not surprised, pleasantly surprised. The carriers are very good. They're very they get their everything in on time, and it's actually really good not to have to deal with any pushback from the carriers. They understand that it's an important database too.
Has there been any discussion, going back to my initial comment about the FTC saying that they'll consult the DNC, the disconnect database? Has there been any discussion about using the R&D data to perform hygiene on the do not call registry?
I'm not aware of.
Seems like it would be a good idea. Mark, how we've talked about the safe harbor. How successful have you been? Have you ever found a plaintiff's attorney that agrees with you?
Are you referring to the reassigned number one or the kind of DNC one?
Well, I think the answer to that is both. I know the answer is both, but I've never found a plaintiff's attorney that agrees with either one of them.
Correct. I will tell you the problem with the safe harbors as they are drafted right now. And again, I don't know if there's necessarily a way to fix these problems, but the problems with them right now are that they are more summary judgment issues, which means that they are issues that are generally raised after sometimes years of litigation. So I, a lot of times, have clients come to me and they present me all of this information about the detailed information or scrubs that they're running against the do not call list, maybe scrubs against the reassigned number database, et cetera. And they say, I don't know how this happened. Call up plaintiff's counsel and, to show them all of this and just say this must have been a mistake. And then plaintiff's response, getting to what Mitch was implying, is, well, if there was a mistake here, there must have been a pretty big mistake that has, affected lots of people. Let's litigate this and figure it out. And are they right? Maybe sometimes, but a lot of times it really just is something just fell through the cracks. And, I've even had plaintiffs' attorneys tell me, hey, if you've got the reassigned number, if you've scrubbed for the reassigned number database and this one just fell through the cracks, then, we're looking for a relatively small settlement. Now, I don't know what relatively small settlement is, but all that means to say is it's not, I don't think, necessarily acting as just the plaintiff's attorneys going, okay, cool, I'll go away. Mitch, is that kind of your experience as well? I know you alluded to that a second ago in your question.
Yeah, that's what I was getting at. The safe harbor here in the R&D context is much different than the safe harbor in the DNC context. The DNC context, you're talking about, you have the policies, you have the procedures, you do the training, you do the oversight, the auditing, but look, lo and behold, you still made a mistake. The R&D safe harbor, at least the way I read it, it's, hey, I did everything I was supposed to do. I queried the database and I got a no. But Beth, let me ask you, does that imply that there are errors in the database?
The no from the database means no, the number has not been disconnected since the date in the query.
Right. So
you're good to call them or text them.
Right, but there's no reason to. But that data, you're just getting that data from the carriers, right?
Yes, it's from the
data
carriers.
Theoretically should be accurate. So I guess where I'm going with this, Mark, is that, the safe harbor, I mean, do you really need it? If the data, assuming the data is accurate, the safe harbor, if nothing else, it really just protects you from initiating calls that you shouldn't call, because the data should all be accurate. It's not like the DNC safe harbor where you're doing everything you can and you could make a mistake.
I think I'm not as intimately familiar with the database as Beth is. I think there are obviously going to be things that occur. That's just, it is what it is. But I hope that the safe harbor was put in there to make people more comfortable, because one thing we haven't addressed too much is the clients that do know about the reassigned number database are sometimes surprised at how much it costs. I know that Beth mentioned this earlier, that the price was reduced by 20%, but I do think that there are some situations where smaller companies find it cost prohibitive. And one thing that I do want to mention is a lot of my clients, Mitch, I'm sure a lot of yours as well, want to ask if they can purchase TCPA insurance. You can, it exists, but it's also highly cost prohibitive, which is unfortunate given how much TCPA litigation has exploded over the few years. Mitch, anything else to add on that?
Well, I just want to go back.
Mitch, we're at the top. We're almost at the top of the hour.
Yeah. The last comment I'll make is the R&D is the safe harbor is absolutely valuable. But Mark, what I'm getting is that it may not be a black and white issue, right? There is gray area in qualifying for that